Okay, going back to section 14 of the Negotiable Instrument Law of the Philippines, section 14, blanks. Okay, we're talking about blanks. When may be filled? Where the instrument is wanting any material particular, the person in possession thereof has a prima facie authority to complete it by filling up the blanks therein. And a signature on the blank paper delivered by the person making the signature in order that the paper may be converted into a negotiable instrument operates as a prima facie authority to fill it up as for any amount. In order, however, that any such instrument be completed, may be enforced against person who become a party therefore prior to its completion. It must be filled strictly in accordance with the authority given when within a reasonable time. But if any such instrument after completion is negotiated to holder in due course, it is valid, effectual for all purposes in his hands, and he may enforce it as has been filled up strictly in accordance with the authority given within a reasonable time. In section 1, it says, when an issuer or a drawer or a maker issue a promissory note only by signing the signature, there is no amount, there was no date, so the person wherein the maker had given the promissory note to fill it up is required to insert the date, the amount, according to the instruction or the agreement made with the issuer. It may be enforced against him because he had signed the signature stating his compliance to pay. And if such instrument, after it was completed and negotiated to a holder in due course, it is valid, effectual for all purposes in his hands, and he may enforce it as been strictly filled up in accordance with the authority given and within a reasonable time. Let's say, for example, the promissory note was only signed, but the amount and the figure of the value was paid blank, but according to the issuer, said you have to fill it up only 4,000, and the date should be payable a month after. Okay, so I'm going away, so I just have to I'm in a hurry, so I just have to sign this promissory note. Then later on, it's for your it's your responsibility to fill it up according to what I had told you. Then if the instrument later on came to a holder in due course. Who is a holder in due course? A holder in due course is the one who paid the value for the instrument in good faith and have no idea that there is any fraud or illegal intention in having this promissory note. So this promissory note can be enforced strictly in accordance with the authority given. See, for example, when the holder in due course had received the money and the one written on the amount is 10,000, it was only can be enforced only up to 4,000 because that's the authority given by the issuer, only for 4,000. So that's basically what this section 14 means. You can fill up a blank promissory note or a bill of exchange as long as it is according to the instruction or of the authority given by the issuer. Beyond that, the issuer is not liable to pay the illegal amount, only up to the authority given, that is 4,000 as what we have mentioned in our example. Section 14. Incomplete instrument not delivered. Where an incomplete instrument have not been delivered, it will not be complete. It will not, if completed and negotiated without authority, be a valid contract in the hands of any holder, as against any person whose signature was placed thereon before delivery. See, we're talking about incomplete instrument not delivered. Unlike in the above in section 14, when it is blank and there was an instruction to fill it up according to his instruction only for this amount, then it is different. In section 14, it's an incomplete instrument not delivered. So the instrument was not is not complete. Like if ever there's a check already signed, but it was only lost. It was only lost, and it was not delivered. It was only lost. The check was found by other party who had no instruction to complete said instrument from the issuer, or the one who had signature was signed on the said promissory note. Then this negotiable instrument, even though if it's completed or negotiated with authority, be a valid contract in the hands of any holder, as against any person whose signature was placed thereon before delivery. Okay? This is different, This is different from section 14, because in section 14, we're talking about instrument blank, leave blank intentionally, because the issuer is in a hurry, but he signed it and delivered it with instruction to the one he had given a prima facie authority to complete said promissory note. And section 1, it's an incomplete instrument, meaning it's lacking with all the information, such as the amount, the date, and the mode of installment or the mode of payment, and it was not delivered. It's either lost or it was taken. There was a theft or anything that happens without any authority or instruction for the one who had the signature was stated therein. Okay, we go now to section 16. So, section 16, delivery when effectual, when presumed. Every contract on a negotiable instrument is incomplete, unrevocable until delivery of the instrument for the purpose of giving effect thereto. As between immediate parties and as regard a remote parties other than the holder in due course, then the delivery, in order to be effectual, must be made either by or under the authority of the party making, drawing, or accepting, or endorsing, as the case may be. And in such a case, the delivery may be shown to have been conditional or for a special purpose only, and not for the purpose of transferring the property in the instrument. But where the instrument is in the hands of a holder in due course, a valid delivery thereof by all parties prior to him, as to make them liable to him, is conclusively presumed. And where the instrument is no longer in the possession of a party's signature appears thereon, a valid and intentional delivery by him is presumed, until the contrary is proved otherwise. Okay. Says in section 16, delivery can only be effected or when it is only presumed. You say if you had an incomplete negotiable instrument, if it is not delivered or it was not given to the person that for the bearing to the bearer, the negotiable instrument is not valid, it is not effective. Why? Say for example, the issuer had issued a check. The issuer issued a check with the date stated today. I'm going to sign this, or that. Then, but the issuer or the maker told the payee, I'll just give you this promissory note tomorrow. So because now I'm still I'm still thinking if I would push through with this, or I have any other option. But the bearer rather the promissory note was left on the table. What the left on the table by the issuer, maybe he forgot to bring the check or the promissory note. What the bearer had done, he took the check or the promissory note, and thinking that anyway we promised that tomorrow I will give it to you, then I might as well take it today. But as I have said, the agreement but that the instrument shall be delivered only by the following day. Comes now that the bearer was asking for a demand for payment, the bearer, the issuer, or the maker of the refused to pay because their agreement is that the following day, and the pinangunahan na what the pay have done, they did not follow their agreement. Okay, what happened if this instrument becomes to the hand of a holder in due course with a valid delivery thereon? We're talking about the holder in due course again. The holder in due course is to get possession of the instrument who paid in value with no idea that prior to the possession of the check there are any illegality, fraud committed. So still it is presumed that it was validly done. Okay?